faculty members, and the students.
Very good afternoon, my dear students, boys and girls. Probably I am facing LLM students, maybe other students of lower classes as well, but of course it will be desirable if at all you one by one in a second or two come on the screen and say hello. The participants, please come on the screen and introduce yourself so that we can proceed with our deliberations onwards.
Students, you can please turn on your cameras and unmute yourself.
Well, my dear students, come online please and have interaction with me. Just say hello. I want to ensure how many people are with me so that I can talk to them fruitfully. My mom and help the students to be on the screen.
Yes, sir. Students, please turn on your cameras. It's a request, students, please.
Well, it's okay, no problem. So I proceed with, I have requested Dr. Pradeep Rai, Senior Advocate, Supreme Court of India. He is a legal luminary and we will be certainly benefited by it. Not only that, even the students who are the future advocates, judges and corporate lawyers, they will take advantage of it. Though of course I know that in corporate people do not commit any crime and they need no defense at all. However, today's deliberation would be common criminal defenses, or you may call it something more than what is, we call it common excuses from section 76 to 106 of Indian Penal Code, where there are certain exceptions to the general rule of criminality. So it will help you as a lawyer, as a judge, and not of course for the people who join the corporate because they have the business and they are never indulged in any sort of criminal activities except taxation, etc. Anyway, over to Dr. Pradeep Rai, the learned. He is more or less equivalent to their lordships in the Supreme Court. He is a pillar in himself in the judicial functioning, defending cases at the topmost court of India. Thank you, Dr. Pradeep Rai. Please, over to you.
Before starting the webinar, I would like to invite Dr. Pradeep Jain, and I would like to give you all a brief about our guest speaker. Sir is a senior advocate and a vice president of Supreme Court Bar Association. He has over 25 years of standing experience at the bar in the Supreme Court of India, various high courts, commissions, and regulatory bodies and tribunals. He has an experience in litigation across a wide spectrum of civil, criminal, revenue, and constitutional issues. He is also the founder of various subcommittees of the Supreme Court Bar Association that includes Grievance Committee, E-Committee, Health Committee, Bar Coordination Committee, Cultural Committee, and State Subcommittee. He has launched several schemes in the interest of the bar. Sir is also the chairman of Indian Legal Aid Center and Indian Legal Research Foundation. Having a deep-seated passion for the access to justice, a renowned human rights activist, Dr. Rai, has closely worked with 25th Chief Justice of India, Honorable Mr. Justice M.N. Venkatachalya, and the 27th Chief Justice of India, late Honorable Justice G.S. Verma, and has played an important role in the area of prison reforms. We are pleased to have you here, sir. Over to you.
Thank you so much for inviting me. I'm thankful to Principal Sir and Nidhi, Mahimaji, and all the other officials of the college and students and any other persons who are participating in this program. You see, first of all, any college, when they invite me, I never say no. And the reason is that I feel actually I feel happy that if I have to participate in any kind of program in a college. I'm clear. I think my audio and everything is clear. Yes.
Yes, sir. It's very much clear.
Yes. So today there is we are going to have especially focus thing that common criminal defenses. You wanted to my lecture on this only, and there is a question answer session also in this. Yes. So okay. So you see, first of all, we all have to understand legal and illegal and presumption. So for any law student, I will always say that when you have to test that whether something is legal or illegal, a common man with a common mind, not with the criminal intent, it should be the genuine and common mind. If they feel that something is good and something is appropriate, that is legal. And if you find that something is not appropriate, then that is illegal. Like if you think that you have to hit someone, you have to kill someone, or you have to commit theft or something, that is illegal, and you will find the offenses in that. But something which can occur by chance, or you feel that because of this the person is not guilty, then the person is not guilty, and you will find that there are certain defenses even if he is charged for the same. As far as rule of law is concerned, whenever the criminal law is tested and whenever there is a proceeding before the criminal law, the burden of proof is generally it is on the prosecution. They have to prove it, unless it is provided in the act itself that you have to prove innocence. Like Tada cases, Makuka cases, Pota cases, or even NSA cases or something like that, where you have to, even dowry cases or PC Act cases, Prevention of Corruption Act. There you have the assumption that you are guilty, and thereafter you have to defend yourself. But otherwise, our law and the criminal proceedings are designed in such a way that 99 criminals may be left, but one innocent should not be proven guilty. Because we don't want to punish an innocent man, and that's why we have taken a kind of proceeding in such a way that it should not happen. And this old British law, earlier the punishment system was also different, but now it's completely as per the code, and we have to follow the Indian Penal Code, CRPC, Evidence Act, and similarly other acts and codes and procedures. Whenever you want that there should be some defense and how to save yourself, because normally what happens in the criminal matters, mostly all the accused persons, they say that assumption that the person is innocent. They say that the accused is innocent, he is no way involved in the case, and then they file the application for the bail. And similarly, when they argue the matter, in the matter also they say the same. Like any person who has done some mistake, like if I ask you, any student, that why you were late in the class. So sometimes they have some pretense, and they know that it's not correct, but teachers may also appreciate it sometimes, and sometimes they don't appreciate. Similarly, in the criminal law, you also take some kind of defense of yourself, and certain defenses which are part of the statute, some certain defenses which is part of the procedure, and some of them have been incorporated. So mostly in the criminal jurisprudence and the criminal system, all the courts, they follow this kind of rule. Like suppose you are just going to argue anything other than the sections. I am not going on these sections, what the section says. I will come on that later. But the self-defense, like if you have been there and somebody is attacking you, and in self-defense you are hitting someone, or you are trying to protect yourself, or somebody is firing at you and you have a licensed gun and you are firing it, or even if to save yourself you do anything, then that part may be covered under the common criminal defenses. Other than that, entrapment, then coercion, that you have to involve yourself into, because of the coercion you are doing something, then there is something which is required to do. Then by mistake you don't know and you have committed some error, and because of that you have done. So many things, like reasonable doubt. One part is this, that normally in Indian jurisprudence, we all create a matter where doubt has to be created. When you argue a case, and you can create a doubt that yes, he may be innocent, because the moment you created the doubt, our system is such that you will be discharged. And because of the doubt, so many accused, they actually get relief, and they are discharged by are acquitted by their offenses. Then other than that, they can say that reasonable doubt, other than that, insanity, then intoxication, then other persons have not been charged for the same offense and they have taken some plea, and you are also benefited by that. Then alibi. Alibi means that you are saying that at the time of offense, you were not available at that point of time and you were somewhere else and some other things you were doing, or you were traveling in the train, whatever it is. But you can, especially you can prove yourself that you were not present at the place of offense. So that gives you a lot of safety, and because of that, this is part of the common criminal defenses. Like if you want to understand, like go through the 2G cases, like a big cases I am taking here, or you are going to take a coal scam, or you are going to take like Amitabh Bachchan's case, or Jayalalitha's Tasi land scam, or any kind of government decisions. Normally what happens when an officer is charged in the PC Act, generally to prosecute him, there is a special sanction required under CRPC, that is 197, in which the officers are given protection that at the point of time when he is discharging his duties, there may be certain incidents or certain responsibilities under which he could have ignored something, and that ignorance is not with the criminal intent. So to prove that, to ascertain that, that's why there is a provision of CRPC 197 where you have to take sanction from the prosecuting authority, from the appointing authority. And who is the appointing authority? Like if I am IPS officer, the Home Secretary of the state, or maybe the Home Secretary, Government of India. If you are IAS, again the Secretary DOPT and the Chief Secretary of the state. If you are MP or MLA, speakers and of the Vidhan Sabha and Lok Sabha respectively, they are the sanctioning authority. So there is a one set where you are part of the discharging government duties, then you are completely covered under sanction rule. And after sanction, then you have to take common criminal defenses. That is for the public servant. But if you are not a public servant, if you are a common man, then only these facts are involved. You have to take the plea. Like in 2G scam, it was a license policy. Government of India brought a license policy. Under that license policy, anybody who has taken 2G license, they had gone for the bid or by the way of allocation. And because of that allocation, it is said that there was a criminal conspiracy with the government and with the officers. And because of that, they got these licenses and they were charged. Ultimately, what happened? All the accused persons had been discharged today. They are not accused anymore. So the scam itself, the accused persons are no more accused. If you, today's status is that they all have been discharged because one person takes the cabinet note and cabinet decision, other person takes in the account that they have come with a policy, and ultimately because of these common defenses, all of them are out. But there is certain time, like, so see, for political reasons, the case was so long and it went on for a long time. But ultimately, what you realize that a scam which was known in the entire world, and because of that, many companies they closed. Because of that, many politicians they had to resign. Ultimately, it was found that there is no offense in this at all, because the moment you create doubt, the moment you take the defenses, you are out of this mess. So what happened in that? The facts they mentioned that 2G scam was not a kind of a scam which was designed for the 2G. Actually, the moment when Government of India was operating 2G, operating for the 2G license, already 4G was in operation. 4G was about to be launched. So Government of India made a policy that any company, if they are interested in taking the license of 4G spectrum, they should have been in operation of 2G license or 2G spectrum. So all those new companies who wanted to take 4G, they did not have 2G, so they were disqualified. Because of that, they wanted that there should be some policy in which they could take 2G license and then they can start 4G. So most of the telecom companies those days who wanted to bid for 4G, they applied for 2G license so that in order to that application, they will be qualified for 4G. When they applied for this, government, because of the Government of India's policy, note of the cabinet and other things, these licenses were allocated, and because of those licenses, many other foreign companies, they also participated in that with their Indian partners or other partners. So when this ultimately this trial commenced, it was supposed to be ruled that the persons who all they got license, that was because there is a revenue loss or maybe something else, whatever the argument, whatever the charges were there is in public domain. But ultimately the discharge that happened because of this common criminal defenses only. Because when you say that at that point of time it was necessity to do, because that is also one of the defense. If there is an error, that is a mistake on part of the officials. It's not that legitimate or bona fide is not there and they are doing it with the criminal intent. Then you are ultimately you are declaring yourself that because of that there is a proper innocence and assumption of innocence is there. So preponderance of evidence has to be appreciated at that point of time, and because of that, all those accused persons has been discharged. Now there is no accused in 2G case, and matter is pending in the High Court because CBI went for the appeal. Ultimately, in so many cases, like if you see Amitabh Bachchan's case, where Amitabh Bachchan has taken a land in Pauna, Bombay, near Pune Road. He took this land, and after taking that land, when he wanted that this land should be registered and mutated in his name, there is a format in Maharashtra government's revenue policies that you can only those can take those lands who already have a certificate of farmer. Because if you want to buy the farmer's land, you have to be a farmer. Unless you have a farmland, you can't have it. So those days, the film stars like Amir Khan and other film stars, they already had some land. So they said that, yes, we are farmers, and they got this. Then Amitabh Bachchan also applied and he said, I am also a farmer. He got a certificate. But the government objected that, no, you are not a farmer. The land doesn't belong to you. Ultimately, he contested the matter and it was revealed that he had a land in Barabanki, and because of that land, he is a farmer and he got a farm certificate, and he could kept the land. So the purpose of my mentioning this is that sometimes intent may be that only farmers should take farmers' land so that others should not acquire. That may be the intent of drafting and putting up this legislation. But what happens in reality? Anybody who has a farmland, they can take it. Like I am owning a farmhouse. Farmhouse means I have a farmland. So a person who is a farmhouse owner can take the farmer's land. That was not the purpose. Purpose was that only farmers who are dependent on agricultural income, they should be buying these properties. But again, there, because of the general mistakes, all these things actually were ignored. It's a kind of rule of evidence law that initially burden of proof is always on the prosecution. It's only after the prosecution and discharge the initial burden, the accused takes defense. The burden shifts on accused to discharge such burden. It is to create reasonable doubt in the mind of the court about the liability of the accused. If it is not the POTA, MACOCA or other sections, then only this part, the moment you created this doubt, you are out of that particular case. And the general defense is provided under Chapter 4 of Indian Penal Code. You all must have gone through with it, so I am not mentioning each and every section in detail and not going in the part of proceedings. Like Section 76 and Section 79 deals with the defense where act is done under different circumstances. Like a person is bound or justified by law to do something and does it. Like I am a police officer, I am carrying a gun, and a mob attacks me, and my superior gives an order that you fire. I fire, but ultimately it was proved that I should not have fired. Because of that fire, this problem escalated, and that was not the reasonable force. Even if it is not a reasonable force, but I did it under direction of my superior, and I am supposed to follow the directions of my superior. So I will not be the accused in that case. And if the person also believes himself to be bound or justified by law and does it, and then owing to mistake of fact is not the falling in the trap of law. The only difference between section 76 and section 79 is that if one deals are bound by law and the letter deals with the justification of law, the concept of respondent superior arises from joint reading of those sections. When public servant is prosecuted for his act, he can take defense that he believes that he is bound by law. In order to follow the superior's order, the burden shifts on superior to prove that this order was not justified. So like if SDMs gives you certain direction, or a commissioner gives you certain direction, like there are many police power, but like many other districts, you will not find police commissioner. You will find that SDM and district magistrate, the civilian officers, they have that kind of power and they deal with it. In those circumstances, the officer who has given the direction will be responsible for it, not the officers, not the person who is executing this. Like further, section 77 deals with the act done by the judges in discharge of their duties, is a defense from the liability under Indian Penal Code. While section 78 deals with the defense where act is done pursuant to order of the court. Like court directs you that you get this house vacated and the possession should be handed over to A or B. In between, the other party has gone to the High Court and the officer is unaware of that. Then the officer can actually, whatever he has done to get the house vacated will not fall in the ambit of any offense. That will be his defense that there was a reasonable, justifiable court order was there. Court order was there and they could have done it. Section 80 deals with accident, which is defense, where person has no element of choice. The act is without knowledge and intention on the other hand. Because you see, when you are driving the vehicle, and while driving, you find that in order to save yourself, you have to take a left or right cut, and because of that, some accident occurs. So when you had been working to save yourself and you drive, and because of that, some accident happens, and you wanted to save a child in front who has come from the wrong side, and then you have taken the left or right, which was not proper as per driving rules, you may not be charged. You will be discharged if there is any offense put on you. Then similarly, section 81 deals with the necessity as defense where a person does not act, where he has to choose between two evils. But saving himself, the person cannot take others' life. That is the one part. But ultimately, that will be the part of your defense, and you may be charged with 304, but not 302. If it is not the genuinely, you are not with intention, you are going to do all this. And then actus and mens rea. Again, you have to, when matter starts, initially I said that legal and illegal, you have to ask your heart that whether you are doing something which is appropriate. The moment it is appropriate, it's legal. When you say that such things are not appropriate, your mind says, your heart says that is illegal. But at the same time, you have to go for so many other things, so many other proceedings, so many other arguments in which you have to establish whatever you have done was not intentional. And your actus, whatever you did, whatever you acted, there was no mens rea. Mens rea is the intent. If there was no criminal intent, you can't be charged with the criminal proceedings. Like you just keeping a child in your lap, and by mistake or because of you got hit from somewhere, your child slips from your hand and falls down, and some accident happens. Because of that accident, you may be charged that you were not careful. But ultimately, you will be discharged because of other circumstances, because that will come to rescue, that will come for your defense. Section 82 and 83 deals with the inoffensive and defense. Section 82 deals with the in apex, where the age limit is 7 years. A person who is not completed or who is not adult, if he has committed some offense, initially you send them to children home and all these places where you can take charge. Other than that, because of this Nirbhaya, one amendment has come where even a 16-year-old boy can be charged and he will not be relieved. He will not get any relief or remedy. But prior to that, if your age is below 18 years, you had so many other things. And if you are not more than 7 years, there cannot be any charge against you. And that itself is a complete defense. The only option is that unless prosecution proves that no, your age is more than this, and whatever certificate you have given, then there is a scientific method by which your age can be ascertained and then the action can be taken. 83 again deals with these 7 years and 12 years age. 84 deals with insanity. Insanity is in two folds. One is the medical and another one is legal. But law recognizes only legal insanity. Medical insanity is proved by declaration of doctor. You will find that there are so many doctors or behavioral science specialists, they give a certification that is subject to review, that is subject to investigation. And ultimately, if it is proven that the person who has committed such offense was actually insane, then the same defense, it will fall in the common criminal defenses. I personally feel that any person, whoever is going somewhere, or suppose you are walking on a street and some two persons are trying to kill someone, you are no way connected with that, but you indulge yourself, you wanted to save the person and you hold one person, and because of that the other person may suppose died. It is not 302, because you had no connection at all with this. And if there was no connection at all, then you cannot be charged. You cannot be charged for such offenses, which falls in this this category. 85 of IPC provides defense where act is done under influence of intoxication. If it's voluntary and certain acts, not all the acts, like if you drink and then you go and kill someone, or if you do something, only certain offenses which falls under the intoxication category, that yes, this may be exempted, like you are driving left, right, or something, or driving itself is that will be charged for the violation of traffic rules and putting the lives in danger. But if you are walking, you fell on someone or whatever, there you may get defended, but you will be charged for intoxication if it is willingly. But if it is not willingly, somebody has cheated you, somebody forcefully or by cheating, they have given you something, and you are not aware that you were in this kind of intoxication, then that will be your defense. 87 to 92, that deals with such defense based on doctrine of voluntaria non fita injuria. Section 87 provides defense where a person is above 18, gives consent for infliction or harm. Like suppose a film star is shooting a movie. I will again give you example of Amitabh Bachchan, that he was shooting the movie Coolie. And because of the demand of the scene, the villain of the movie, he hits him, he got injured, he was hospitalized. It doesn't mean that the person who was part of that acting should be arrested. So he was not arrested because this was part, and Amitabh Bachchan had willingly given this. Similarly, like you are organizing a circus and you are participating in it and you fail, you can't charge your owner of your circus company that because of whom you have got injured and hurt. So you have to deal with such defenses, and you all know that just by keeping the hand on your heart, you will understand that whether this defense is provided or it should not be provided. Sections may be different. In the US, you will find different section. UK, you will find different section. But facts are same, because general principles of administration of criminal justice is almost same. In any country, wherever you go, you will find that these defenses are almost same. Section 88 and 89 and section 92 deal with such defense where act is done for the benefit of the victim. These sections are of great importance to the doctors during treatment of patients. Like when you are committing or you are going for the surgery, normally doctors take your declaration. Suppose there is a case where declaration, there was no one to give you declaration. Then how to deal with it? And doctor feels that surgery is urgent. If he doesn't conduct the surgery, the patient may die. And doctors, they team of doctors or one doctor, they sign it and they commit the surgery and patient does not survive. They may be charged, but the case will not stand because it will be without any legs. That's why I always say that doctors, whenever they go for the surgery, whenever they go for the treatment, and if they give you some medicine, and suppose it gives some reaction, and there was no reasonable time to verify that whether such medicines react on you, but to save your life, it was urgency and necessity. Again, that can come for their rescue, and they can be actually saved because of that. While under section 89, the consent given by the guardian or by some other persons on behalf of minor, that also falls that kind of defense, and 92 deals with the extreme situation where no one is there to give consent. In these cases, doctors actually can be saved. Section 96 to 106 deal with private defense. The law expects that when a person is in a grave situation where there is a risk of his life or he may suffer with the injury, the person should not flee away from such danger, but he should face it, provided there shall be no recourse to public authorities. There is a private defense to protect human body as well as property of himself or the other person. Suppose there are dacoits, they attack your house, robbery is happening. You have a licensed gun. What option you have? You have to fire on the robbers. You have to fire on encroachers. It's late night and somebody is attacking your house. They are committing theft or committing burglary or even robbery. Or there is a assumption or threat that he may also kill you. In that case, to save your property, save your life, you have to use force. And that force is part of this common defenses. Section 98 says that private defense can be exercised if harm is from the side of minor, intoxicated and insane person. Section 9 says that one should not inflict more harm than necessary. Like when, suppose you are a police officer and a mob comes, then you have to fire. That should not be above the waist. It should be below the waist. Because your purpose is to save yourself. Your purpose is to disperse the mob. You should not fire somebody's head, chest. That person may die, or the injury should be put his life into danger. So that part we have to take care, and you all have to recognize that whenever an officer is using the force, he should use only reasonable force. In any charge sheet, if many of you must have read the charge sheet, or you must have read the arrest memo, you will find that so and so was arrested on such and such offense, and then the reasonable force was used to arrest him. Like you see some visuals where you find that a person accused is being beaten in the police custody, there is no defense for that. The person who is a criminal, he may do something wrong, but the officers who have to follow the law, they have to lawfully discharge their duty. Your job is to arrest, send them to the prison. It should be tried, and the person may be prosecuted or convicted or may be discharged. But when the police officers themselves start killing the people, or they start taking the law into their own hand, that cannot be defended. You see, there are so many cases which are pending for years. It may appear like, you see, many officers of Gujarat police, they found themselves into prison, they retired from the prison. There is a very famous encounter of Delhi at Connaught Place, where two businessmen were actually killed by mistaken identity. And when they died, when they were killed by the police officers, they thought that, yes, we have committed the mistake. And when they realized, they thought that why not to plant something? If we plant some gun and everything, we can be saved. And we can establish that, yes, they were criminals and they were roaming around in Connaught Place. When they planted this, ultimately they all were charged and they are undergoing life sentence in Tihar jail. But suppose they were genuine criminals, and then they would have done the same. They would have been saved. Like in case of Amjad Khan versus the state of MP, it was in 1952. It was held that there can be a scale fixed in grave situation about the extent of private defense, while section 100 and 103 mentions about situation where that can be caused in exercise of private defense. In self-defense, you have to fire. You have no other option. Section 101 and 104 says that when harm other than death can be caused, and section 106, while exercising the right of private defense, even if innocent person is harmed, it is a complete defense. While driving, or while suppose the police officer is firing on a criminal, because criminal is going to take few lives, if one innocent person also get hurt, this will be part of your defense. It should not be deliberate. Then section 11 of Evidence Act, you all have gone through with it. It has been proven by alibi, which I said earlier, that when you take alibi, that is a basic defense in which many cases you get discharged. Sometimes you say that I was not available at the incident of offense, I was not there, I was somewhere else. And many cases are like this. I have been observing generally courts do not accept it unless there is a strong presumption and everything is there to establish that the person was actually not available and he has been seen there. But it may be applicable only in prominent cases. But generally, if your alibi is correct and if it is appropriate, you will not be charged. So the only purpose of object of these defenses are that if the person has acted on something, but there was no mens rea for the same, then the person should not be charged for the offense which he has committed, and you find that that has been committed by the mistake or by the assumption that he is correct, or by the assumption that it happened because of he was intoxicated. So these facts are there. And also, when you actually go and follow all these facts, you have to realize that basic purpose of these defenses are only on the presumption that 99 guilty may be released, but one innocent should not be punished. And because of that, such kind of laws were actually enacted, brought, and is prevailing. Now UK has different criminal procedure, different code. US also had the new one. We also have the old one, but so many amendments have been incorporated. Despite that, all these defenses are permanent feature of any criminal procedure code, any penal code. And that is necessary in order to protect the innocent citizens, in order to maintain the law and order, in order to have a civilized society. You should have these remedies. And these remedies give you a kind of permanent solution of anyone whenever you deal with a situation where you find that in such case that action was required and necessary, or you have done with bona fide, you have done under direction of an officer, you should not be charged. All these similarly, if there is a procedural irregularity, you find that particular procedure was not followed, even that is also your defense. Because there are judgments and there is a procedure, that if there is a procedure mentioned in the law, then the thing should have been done in the way it has been mentioned. Neither less nor more, nor any application of mind. Because then the procedure, otherwise you will violate the rule of procedure. And similarly, the duress is there. When you say that somebody forced you to commit this, like if somebody is threatening you and you are under control of someone and because of that you are doing it. So again, the duress is one of the major defense in which you can take. So these are the general defenses. I think that students may, if they have any questions, they can ask, because thus addressing like this will not be benefiting. If you all have any question, please ask. I will be happy to respond to it. And next time I will like to come personally on any weekend, and then we can have a good conversation.
Students, you can please write in your questions in the chat box, or you can directly unmute yourself and ask sir directly.
They can ask any question, because I don't want that they should be restricted to this only. Any kind of question you want to ask, you can ask.
Students, is there any queries? You can directly unmute yourself or put your questions in the chat box.
This is very good. They have understood everything, it appears, and I'm really thankful that you invited me. It's a good opportunity to interact. Today in my office is the intern day, so I meet my interns, and today we have around 300 interns, so I'm just going to deal with them, and they are also witnessing whatever we talk. It's very nice. And my interns are from every college, from your Kashmir to Kanyakumari. They all are very happy to see. Thank you, Principal Sir, for organizing this program.
Thank you very much for the useful.
Thank you, Mahimaji. Thank you, Nidhi. Thank you, everyone. I'm really grateful. Thank you so much. Should I leave now?
So, just a minute, sir.
Yes. Thank you.
Thank you, sir, for addressing the students and helping them with your experience and knowledge. CPJ family is always thankful to you. I would like to thank you for your valuable time and presence in our today's webinar. I would also like to express my deepest gratitude to our General Secretary, Dr. Abhishek Jain, and our Director General, Mr. Yugang Chaturvedi, for providing us such platforms to nourish our students in a holistic way and always giving us a vision-oriented learning. At the end, I would like to thank all our senior functionaries for their support and guidance for organizing this successful webinar. At the end, I want to thank our students for attending this webinar. Thank you, everyone. Stay safe, stay happy.
Thank you so much. Thank you.
Thank you, sir.